Her name is Fatima. She's 28 years old. She's a paralegal at a small law firm in Garki, Abuja. Every day she reads court documents, petitions, motions, orders, stays. Legal language has become the language she thinks in. She knows what a stay of execution means. She knows what a subsisting order means. She knows what it means when a lower court judge proceeds with a judgment despite a superior court's directive to stop. On June 15, 2026, Fatima was at her desk when a notification came through on her phone. Federal High Court orders deregistration of ADC. She read it twice. Then she pulled up the court records she had been tracking. She found the earlier order, the Court of Appeals stay, issued on May 22nd, directing Justice Lifu to suspend further action pending the appeal hearing on October 27th. She read that too. Then she put both documents side by side on her screen. She is not an ADC member. She is not a Tinubu supporter. She is not an Atiku supporter. She is a Nigerian citizen who has spent 3 years watching courts, agencies, and institutions used as tools in political competition. And what she is looking at on her screen is a federal high court judge delivering a deregistration judgment after a superior court told him to stop is the thing that worries her most about January 2027. Not who wins, not which party, the system in which the result will be produced. What is happening in Fatima's office is really about the question that every Nigerian who cares about 2027 should be asking. When courts can be used this way, is the opposition's problem about finding the right candidate and the right coalition, or is it about something more fundamental than that? And can the ADC court battle break the opposition apart before anyone votes? Stay with me. Before we go deeper, if you are just finding Naija News Watch, welcome. This channel exists to break down what is really happening in Nigerian politics without the noise and without the spin. If that is the kind of analysis you enjoy, hit subscribe and stay with me, because this story is about to get a lot more interesting. Let me build the timeline, because the ADC court battle is not one event, it's a sequence, and the sequence is the story. January to March 2026, the ADC emerges as the primary opposition convergence platform. Atiku Abubakar, Peter Obi, Kwankwaso, Rotimi Amaechi, Aregbesola, David Mark, and others gather under its banner. The Ibadan Declaration of April 25th produces a commitment to work together. For a brief moment, the ADC looks like it could host a genuine unified opposition. Late April, early May, the cracks begin. Court cases about ADC leadership between the Nafiu Bala faction and the David Mark Aregbesola faction multiply. The Supreme Court rules in Mark's favor on April 22nd, but sends the substantive dispute back to the Federal High Court for continuation. Peter Obi describes the ADC as infiltrated by destabilizing agents of the Nigerian state. On May 3rd, Obi and Kwankwaso leave for the NDC. The ADC coalition is fractured. May 22, 2026, while the ADC is managing its internal disputes, a completely separate legal action begins moving. A federal high court, Justice Peter Lifu presiding, begins hearing a petition against the ADC and 4 other parties filed by the incorporated trustees of the National Forum of Former Legislators. On the same date, the Court of Appeal issues a stay order directing Justice Lifu to suspend further action pending the appeal hearing on October 27, 2026. May 26, 2026, Atiku wins the ADC presidential primary with 1.8 million votes. He is now the confirmed ADC presidential flag bearer. June 15, 2026, 3 weeks ago, Justice Lifu delivers his deregistration judgment, ordering INEC to deregister the ADC and 4 other parties. This is done despite the Court of Appeal's May 22nd stay order, which directed him specifically to suspend further proceedings. June 16, 2026, within 24 hours, the Court of Appeal immediately stays the deregistration order. INEC itself applies for the stay. The ADC's platform survives, for now. But the damage is in the public record. A federal high court has ordered the ADC's deregistration. An appeal stay is holding it back, and the October 27th hearing will determine whether the stay holds or the deregistration is confirmed. That is the timeline, and Fatima, reading both orders on her screen, knows exactly what it means. Let me explain the legal and institutional framework, because the rules that govern this court battle are also the rules that determine whether the ADC survives as a 2027 platform. Section 225A of the 1999 Constitution. This provision requires registered political parties to win minimum electoral performance thresholds, specifically a minimum percentage of votes in prescribed elections, to maintain their registration. Parties that fall below the threshold can be deregistered by INEC. The ADC's response is that it was never given a genuine opportunity to field competitive presidential candidates until Atiku joined. The hierarchy of courts. Nigeria's court system operates in a clear hierarchy. Magistrate courts, state high courts and federal high courts are the same tier, Court of Appeal above them, and the Supreme Court at the apex. When a superior court issues a stay order to a lower court, that stay is legally binding. A lower court judge who proceeds with a substantive ruling after a superior court stay has, at minimum, created grounds for the ruling to be set aside on procedural grounds, and in the ADC's specific characterization, a flagrant disregard of a superior court directive from a superior court. For Fatima, the consequence is direct. As a paralegal, she knows that a judgment made in violation of a superior court stay is procedurally vulnerable. The ADC's appeal is not just arguing that the deregistration is wrong on the merits, it is arguing that the process by which the judgment was reached itself was legally defective. That procedural argument, if accepted, gives the Court of Appeal grounds to set aside the judgment entirely, independent of whether the ADC meets the electoral performance threshold. The gray area is the relationship between legal validity and political timing. Even if the Court of Appeal ultimately vindicates the ADC on October 27th, the 7-week window between the June 15th deregistration order and the appeal hearing created a period of maximum political uncertainty precisely during the NDC's primary season and INEC's candidate registration window. A platform that is legally alive but publicly described as deregistered for 7 weeks suffers political damage that no court order can fully repair. Now let's follow who benefits from this specific sequence because court orders do not file themselves. The petition was filed by the incorporated trustees of the National Forum of Former Legislators. This is not a prominent civic organization. The ADC specifically stated that the case was actively promoted by individuals closely associated with the President's Chief of Staff. Atiku directly accused President Tinubu of being behind the judgment. The presidency did not issue a public denial. These allegations are not proven by documentary evidence, but the timing, 3 days after Atiku won a presidential primary, 9 months before a presidential election, with INEC's candidate registration deadline approaching, is the political reality that shapes how every observer reads this story. Who benefits from the ADC's platform being legally challenged at this moment? The APC, which needs opposition fragmentation to repeat its 2023 plurality win. A divided opposition that is fighting in court rather than campaigning is an opposition that is not a threat. Who benefits from the ADC surviving? Atiku, whose 1.8 million primary votes and Northeast networks are his leverage in any 2027 negotiation. David Mark, who built the ADC coalition and whose political legacy is invested in its survival. And paradoxically, the NDC, which benefits from an ADC surviving because an ADC that forces Atiku to find a new home makes the NDC the obvious destination. Who are the silent players? Obasanjo. Sources confirmed he held talks with Kwankwaso in Abeokuta, lobbying for Kwankwaso to accept VP on an Obi-led ticket. That mediation role, a former president quietly brokering between opposition figures, is the most consequential back channel in the entire story. If Obasanjo can broker an ADC-NDC coordination agreement before October 27th, the court battle becomes irrelevant because the key figures are already aligned. If he cannot, October 27th becomes the moment that determines whether the opposition is one coalition or two. Now, if what I just laid out surprises you, drop a comment below. I want to know your take before we get to the part that changes the whole picture. And here is the part that changes the whole picture. There is a specific irony buried in the ADC deregistration story that has not been widely noted. The legal provision used to justify the deregistration, Section 225A's electoral performance threshold,
was specifically difficult for the ADC to meet because the APC controls the electoral environment in most Nigerian states. When you cannot field competitive candidates because the incumbent party uses state resources to suppress opposition performance, and then you are deregistered for failing to achieve competitive electoral performance, the process has a secular logic that favors incumbency by design. The ADC's National Publicity Secretary made this argument explicitly. But it is an argument that requires courts to look beyond the letter of the threshold provision to the conditions that produced the failure to meet it. Nigerian courts have not consistently taken that approach, and that is the legal vulnerability that the deregistration petition exploited. Let us come back to Fatima in Garki. Fatima is not worried about the ADC or the NDC or the APC as political brands. She is worried about something more fundamental. She is a paralegal. She reads court documents, and what she read on June 15 was a judge delivering a ruling that a superior court had specifically told him not to deliver. That is the thing that worries her, not who wins the presidency. Whether the system that produces the result, the courts, the institutions, the regulatory bodies, is functioning with the independence and integrity that makes the result trustworthy. For ordinary Nigerians like Fatima, the ADC court battle is not primarily about which party fields a presidential candidate. It is about whether the institutional environment in which the 2027 election will be conducted can produce a result that Nigerians accept. Because a result that does not feel legitimate, even if it is legally validated, is a result that produces post-election conflict, social instability, and continued erosion in trust in democratic institutions. The economic consequences of that instability are real. A Nigeria that emerges from a disputed 2027 election with contested institutional legitimacy is a Nigeria that struggles to attract foreign investment, to manage its debt obligations, and to maintain the macroeconomic stabilization that the CBN has been working to build. Every month of post-election legal controversy is a month of investment uncertainty. Fatima understands all of this. She works in a law office. She knows what happens to countries where court orders are used to shape elections. She put the two documents side by side on her screen, and what she felt was not partisan anger, it was institutional grief. The international dimension is direct and current. Atiku described the ADC deregistration as an attempt to destroy Nigerian democracy, and specifically appealed to the international community. Nigerians and the international community can see the level of desperation. That framing was deliberate. He's building an international accountability argument. His planned U.S. visit to engage policy and institutional stakeholders on Nigeria's security and governance deterioration is specifically designed to carry this argument to Washington. The Von Batten Montagu York lobbying firm, which has already been briefing congressional offices on Nigerian electoral integrity, will incorporate the ADC deregistration episode into its advocacy material. For the EU Election Observation Framework, the ADC deregistration is a Level 1 election environment concern. Observers assessing Nigeria's pre-election environment specifically track whether legal mechanisms are being used against opposition platforms. The June 15 order and its 24-hour reversal will appear in every pre-election assessment report. The most globally relevant connection is democratic backsliding. The use of deregistration petitions, electoral performance thresholds, and court orders to weaken opposition parties before elections is a documented pattern in multiple emerging democracies, Hungary, Turkey, and several African states. International democracy organizations track whether Nigeria's institutional environment is moving toward or away from that pattern. The ADC episode is being read as a data point in that assessment. Let me give the strongest argument for why the ADC deregistration petition was not political manipulation before explaining where that argument breaks down. The argument is this. Section 225A exists for legitimate reasons. A party ecosystem with dozens of registered parties that cannot win elections, that do not have genuine national structures, and that exist primarily as vehicles for individual political figures to maneuver between elections. That ecosystem wastes regulatory resources, confuses voters, and dilutes the legitimacy of electoral outcomes. The ADC has never won a governorship in its history. It has minimal National Assembly representation. Applying the electoral performance threshold to the ADC is applying the law as written. Moreover, the Court of Appeal's 24-hour reversal of the deregistration order proves the system works. A lower court overstepped. A superior court corrected it within 24 hours. The institutional correction mechanism functioned. The ADC's platform was never actually lost. It was threatened for 24 hours and then protected by the appellate system. That argument has genuine substance. Electoral performance thresholds are legitimate. The Court of Appeal did act quickly. The ADC is currently registered. Where it breaks down is in three specific facts. First, Justice Lifu was aware of the Court of Appeal's stay order and proceeded regardless, a conduct that the ADC described as flagrant disregard of a superior court's directive. Even if the deregistration is ultimately legally correct on the merits, the process by which it was delivered was procedurally defective. Second, the timing. 3 days after Atiku's presidential primary, 9 months before the election, with INEC's candidate registration deadline approaching, is not the timing of routine legal housekeeping. Third, the specific involvement of individuals linked to the president's chief of staff in the petition, as alleged by the ADC, creates a circumstantial picture of political motivation that the government has not publicly addressed.
The question that Nigerian democracy needs courts to answer is not whether Section 225A applies to the ADC. It is whether the application of Section 225A to the ADC at this specific moment reflects the rule of law or the rule of political convenience. Here is what to watch between now and October 27 and beyond. Watch October 27, the Court of Appeal hearing. This is the most important single institutional date in Nigerian politics between now and the January 2027 election. 3 outcomes are possible. The Court of Appeal reverses the deregistration entirely, validating the ADC's platform and clearing Atiku to contest. The Court of Appeal upholds the deregistration, forcing Atiku to find a new platform immediately before INEC's candidate deadline. Or the Court of Appeal grants further delay, extending the uncertainty into November, which itself becomes a political weapon. Watch whether Atiku and Obi hold any formal or informal coordination meeting before October 27. The Obasanjo mediation is the most important back channel currently active. Any reported meeting between Obi's camp and Atiku's camp, joint statement, shared platform commitment, or even a credible rumor of a coordination discussion signals that the October 27 outcome matters less because the key actors are already in negotiation. If no meeting occurs before October 27, it signals that each camp is waiting for the court to create the conditions for accommodation. Watch whether any additional opposition parties face similar deregistration petitions. If the ADC petition is followed by similar actions against other smaller opposition parties in the months before January 2027, it will confirm the pattern that the opposition allegations suggest. A single petition can be explained as routine legal enforcement. A pattern of petitions targeting parties that hosted opposition presidential figures would be harder to explain as anything other than institutional pressure. Watch INEC's public communications on the ADC's status. INEC itself applied for the stay of the deregistration order, an unusual move that suggests INEC does not want to implement a deregistration of this nature this close to an election. Watch whether INEC makes any public statement clarifying the ADC's registration status, the candidate registration process, or the impact of ongoing court proceedings on its timeline. Worst-case scenario, the October 27 hearing is delayed, the deregistration stands past the INEC candidate registration deadline, Atiku cannot find a clean platform in time, and the Northeast's 1.8 million primary votes are effectively removed from the 2027 opposition picture. The ADC court battle succeeds in breaking the coalition not by convincing voters, but by removing a platform before they can vote. Best-case scenario, the October 27 appeal succeeds and the deregistration is reversed with a ruling that specifically addresses the procedural defect of Justice Lifu's conduct. That ruling strengthens the ADC's legal standing and creates conditions for an Atiku-NDC coordination agreement, a formal pre-election alignment that converts the court battle's political pressure into the very coalition formation that voluntary negotiations could not achieve. At the beginning of this video, Fatima had 2 court documents open on her screen: the Court of Appeal's May 22 stay order and Justice Lifu's June 15 deregistration judgment, delivered despite the stay. She was not angry about a party. She was grieving something institutional. Here is what I can tell Fatima. The ADC's platform is currently alive. The Court of Appeal acted within 24 hours to restore it. INEC itself applied for the stay order. The system's correction mechanism worked. Imperfectly, slowly, after the damage was done in the public record, but it worked. That is not nothing. It is actually important. A country where court overreach is immediately corrected by a superior court is not a country where institutions are fully collapsed. It is a country where institutions are being contested, where their integrity is in question but not yet destroyed. The question Fatima is really asking, not about the ADC specifically, but about the system that will produce January 2027, is whether those correction mechanisms will hold under greater pressure. Whether the superior courts will continue to act independently when the political stakes are even higher. Whether INEC's procedural independence survives the most contested election in Nigerian history.
She cannot answer that from court documents alone. That answer will only come on January 16, 2027, and in the weeks that follow. But what she can do, and what every Nigerian who reads court orders and understands what they mean can do, is watch, document, bear witness, and vote. The court battle can break a coalition. It cannot break a citizen who shows up anyway. What do you think? Can the ADC court battle break the opposition apart, or will the October 27 force the coalition together? Drop your analysis in the comments. If this breakdown gave you clarity on what is really going on, do me a favor. Share it with one person who needs to understand this. Like the video, subscribe to Naija News Watch, and I'll see you in the next one. Stay sharp.